You've been involved in a Florida car crash. A few days later, the other driver's insurance adjuster calls you. They sound friendly. They say they just need a quick statement. The question is, should you talk to the other driver's insurance company? Now, as a Florida personal injury lawyer, here's the answer you need to hear. In most Florida car crash cases, you are not required to give a recorded statement to the other driver's insurance company. Let me repeat that. You are not legally obligated to speak to the at-fault driver's insurance company. Their job is not to help you. Their job is to protect their insured, their driver, and minimize the value of your personal injury claim. Now, when an insurance adjuster calls after a crash, they're gathering information to evaluate liability and damages. They are trained to ask questions that may shift partial blame onto you, minimize your injuries, lock you into a version of events before you know the full extent of your injuries. In Florida, we operate under a modified comparative negligence system. If they can argue you are partially at fault, your recovery can be reduced. If they can convince a jury that you're 51% or more at fault, you won't recover anything for your medical bills or pain and suffering. Even simple statements like, "I'm feeling okay," can later be used to dispute your injury claim. Now, there's an important distinction here. You do have a duty to cooperate with your own insurance company under your policy, especially for PIP or personal injury protection benefits in Florida. If your auto insurance company asks for a statement, give it, and be sure your lawyer is with you when you do. But that duty does not extend to the other driver's bodily injury or BI insurance carrier. When you're pursuing a BI claim or seeking compensation for medical bills, lost wages, pain and suffering, you should be cautious about speaking directly with the opposing insurer. Here are some common tactics used by insurance companies after a Florida car crash. Requesting a recorded statement immediately. Asking broad medical history questions. Requesting blanket medical authorizations to your providers. Offering a quick, low settlement before you finish treatment or even within days after a crash. These strategies are designed to control the narrative early and limit the value of your case. If you're contacted by the other driver's insurance company, you can politely say, "I'm not comfortable giving a statement. Please contact my attorney." That is completely appropriate. Once you hire a Florida personal injury attorney, the insurance company must communicate through your lawyer. That protects you from saying something that could damage your claim, which underscores why it's so important to talk with a personal injury lawyer as soon as possible after a crash. So, should you talk to the other driver's insurance company after a Florida car crash? In most cases, no. Not without legal advice. I'm George Palaidis, a Florida personal injury attorney. If you've been injured in a car crash, protect your rights, protect your statement, and make sure the insurance company doesn't control your case before you do.